The
Institute for Justice.
The National Law Firm for Liberty.
Hello, and welcome to Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sanders, director at the Center for Judicial Engagement at the Institute for Justice. If you enjoy this podcast, you should check out our newsletter, an often irreverent take on recent Court of Appeals opinions, which we publish every Friday. You can subscribe at shortcircuit.org. And check out our sister podcast, the documentary series Bound by Oath, while you're there as well. We're recording this on Thursday, May 13th, 2021. As usual, we've got two lawyers here ready to bring you up to speed on a couple recent cases. One that regular listeners have heard here before is IJ's own Bob McNamara. Bob, welcome back to Short Circuit.
Thanks for having me.
And as for the other, Bob and I have a special guest that we are honored to announce, David Latt. Now, David is known for many things. Founder of Above the Law, legal recruiter, federal prosecutor, Yale law grad, even novelist. The list is a long one. But to me, he's two things. First, let me tell you a story. It was 2005. Among the sophisticated crowd, there was a buzz of anticipation that no one had felt since the summer of 1990, when everyone was waiting to find out who killed Laura Palmer. And this included the question of who was the writer of the blog Underneath Their Robes, a man or a woman? If I remember correctly, Judge Posner thought the former, and we soon learned he was right, because unlike the endless stringing along David Lynch gave with Twin Peaks, we soon found out that the anonymous Article III groupie was none other than Mr. David Latt. And although I think most people my age have moved on to calling him his real name, David, you'll always be Article III groupie to me. And that's one reason we have you on, is that although you're not using that pen name, you're getting to relive a bit of those old times with your new newsletter. So tell us a bit about that, which, by the way, I've subscribed to, and so should our listeners.
Well, thanks so much, Anthony. It's great to be here. My new newsletter, it's called Original Jurisdiction. It's hosted on the Substack platform. It's at davidlatt.substack.com. And in many ways, it has a lot of the DNA of Underneath Their Robes. I'm trying to offer an insightful insider's take on what's going on in the federal judiciary. But I also go beyond what I covered at Underneath Their Robes. I also cover the world of law firms, for instance. So in some ways, there are a lot of similarities. It's not quite, I think, as irreverent or snarky, but I do try to keep it candid and authentic, just like Underneath Their Robes.
Yes, well, I'm sure we all have matured somewhat in the last 16 years. So I think that maturity has very much shown itself in the last few newsletters, and I look forward to more. I said there were two things that David is to me. The second thing is an inspiration. Now, as many of you know, David was one of the very first people in the legal community to catch COVID in March of last year. And he publicly wrote about it in real time. So many of us could read about that on his Twitter account. And the reality of the pandemic really hit home for a lot of people through reading what happened to him, especially as his condition worsened and then he was on a ventilator for 6 days. We were, of course, so relieved when the news came that he was on the recovery. I remember checking Twitter over the weekend to see, I'd met you once in my life before this, but it was you're such a figure to so many in the legal community. You just want to know, is David okay? Is it going to be okay? Well, it was so good to see when you were on recovery. Of course, it's been a long recovery, but it really sunk into so many of us just how real COVID was and how we need to be careful. And so that has been a helpful thing to many of us over the last year. So I want to say on behalf of everyone at IJ to thank you for your inspiration. I'm sure many of my colleagues had the same reaction. Anything about that you want to say for our listeners?
Really, the thanks are all mine, Anthony. When I was sick and in the hospital for 3 weeks, I just got such an outpouring of love and support and good wishes from so many in the legal community especially. And it really helped me through that difficult period. It was a scary time. In some ways, even scarier for my husband and my parents and my family and friends than for me, because I was pretty out of it for most of the time.
Right.
But I think we pulled through because of all the support that we received. So I'm really glad to be here, and I'm happy to report that today I feel fairly recovered. I think the only thing is maybe I get a little bit shorter of breath than usual when I exercise, but in terms of my day-to-day, things look good. I saw the pulmonologist recently. I saw the cardiologist recently, and everything looks pretty okay, almost back to normal. So I'm happy to report that a year and change later, things look good.
Well, that's very good to hear. Appreciate that. And if you want to hear more of the full story of David's battle with COVID, but also the Article 3 Group story and other stories, I know he's been a few places lately where you can check him out, but especially at the Advisory Opinions podcast over at our friends at the Dispatch. I think their episode on April 12th, they did a deep dive with him where you can hear more of this. But here on Short Circuit, our deep dive is to get underneath their robes with a couple cases. So, David, you're going to tell us about a recent one from the 11th Circuit, Gill versus Winn-Dixie stores. What's up with Winn-Dixie and their website?
Yeah, so this case was decided on April 7 by the 11th Circuit, and I actually learned about it from Short Circuit's excellent roundup, which I always check when I prepare my own weekly legal news roundup for original jurisdiction, which I call Judicial Notice. And I think the summary from Short Circuit is a fairly good one. The question, as described by Short Circuit, is, can a grocery store be held liable under the ADA because its website is not accessible to the visually impaired? And the holding, is summarized by you guys, and I think accurately, is nope. A website is not itself a place of public accommodation under the ABA, and the website's limited functionality does not prevent visually impaired customers from visiting the physical store. So this is a very interesting case of statutory interpretation. The panel was divided. Judge Lisa Branch, a Trump appointee to the 11th Circuit, wrote for herself, and Judge Reeves, who was sitting by designation, he's from the Eastern District of Kentucky, and then Judge Jill Pryor, because of course there are two Judge Pryors on the 11th Circuit, Judge Jill Pryor filed a dissent. So the deal with Winn-Dixie's website is it is not a website where you can actually make purchases, but it's a website where essentially you can enhance your shopping experience. You can get coupons electronically handled so that you don't have to cut them out and present them. You just give your Winn-Dixie customer card and they'll be automatically processed to the coupon discounts. And you can also refill existing prescriptions using the website. So the plaintiff in this case, a man by the name of Juan Carlos Gill out of Florida, uses screen reader software to read websites because he is legally blind. And because the Winn-Dixie website is not optimized for screen readers, he was not able to take advantage of the website. So in 2016, he sued Winn-Dixie, which, as many of you know, probably is a chain of grocery stores or supermarkets out of the Southeast. And he alleged that the website was a place of public accommodation under the ADA, and that the company must therefore provide full and equal enjoyment of the website to disabled customers like himself. He also alleged, based on some dicta that had been in some prior 11th Circuit cases, that the website has, quote, a direct nexus to the physical stores and pharmacies, and therefore, under the ADA, the Americans with Disabilities Act, Winn-Dixie was required to make this website readable and accessible to the visually impaired. So Winn-Dixie admitted that its stores, its physical stores, are places of public accommodation, but denied that its website is. There ended up being a bench trial, and the district court ruled in favor of Gill. The district court did not address the question of whether a website is a place of public accommodation under the ADA, but instead, relying on 11th Circuit precedent, the district court found a sufficient nexus, nexus being the key word, between the website and the physical stores, such that the inaccessible website denied Gill equal access to the physical stores. So after the bench trial, Winn-Dixie took an appeal, and there were two major issues in the case. There was also a minor issue on standing that was quickly resolved. Everyone agreed on that. The first is, are websites places of public accommodation within the ADA? And then second, does Winn-Dixie's inaccessible website otherwise violate the ADA? On the first question, I actually think this question is not too difficult, although there is a circuit split on it. The ADA has this long laundry list of places that are places of public accommodation in the statute, and they're all physical places. Restaurants, grocery stores, hotels, things like that, and websites aren't listed. And the DOJ has never taken a position on whether websites are public accommodations. So based on this statutory language, the 11th Circuit concluded that websites are not places of public accommodation. There's now a circuit split on this, with 4 circuits taking the view that they are not places of a public accommodation, and 2 other circuits taking the opposite view. The second question, which I think is a bit harder, is does the website otherwise violate the ADA? Because the ADA provides that a place of public accommodation can be liable if it, quote, fails to take such steps as may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services, close quote. So then the issue is a visually accessible website an auxiliary service that Winn-Dixie was required to have? Here, the majority answered no, making a number of observations, pointing out that the website is not a point of sale, it's a limited use website, pointing out that Gill was able to use the physical stores for years and did so without an issue. And the majority essentially declined to adopt a standard that would require disabled and non-disabled customers to have identical experiences. In dissent, Judge Pryor, like the district court, declined to reach the places of public accommodation issue, whether websites fall under that. But she really relied on the auxiliary aid and services language and said that Winn-Dixie, by not having this accessible website, failed to provide an auxiliary aid that was necessary to give visually impaired customers full and equal enjoyment of Winn-Dixie's services. And for example, she cited evidence in the record showing that when Mr. Gill wanted to refill a prescription, instead of being able to do so on the website, like non-visually impaired customers, he had to go to the store, he had to ask for employee help, he had to tell the pharmacist what he needed, he had to wait 20 or 30 minutes to get it refilled. Sometimes he had privacy concerns because he would have to say the name of his medications out loud and maybe other people could hear it. Similarly, if he wanted to use coupons, he had to get employee help. Sometimes the employees seemed annoyed or irritated. So, in Judge Pryor's view, providing an accessible website was necessary to ensuring that disabled customers like Gill are not, quote, treated differently under the ABA than sighted customers. So really, just to kind of reduce it all, at the end of the day, the question is how far does a business need to go in providing similar experiences to disabled and non-disabled customers, and how similar must those experiences be? And I think this is an interesting and important question for 2 reasons. One, there are millions of Americans who have disabilities. And 2, as companies make increasing use of websites and apps, the extent to which the technology must be accessible to disabled individuals is going to become increasingly important. The other thing is there are tons of these lawsuits floating around in the lower courts, these ADA lawsuits. And, their critics say, well, they're kind of like nuisance lawsuits. People find some kind of really trivial violation or alleged violation and try to sue and get a settlement. So there is a lot of this litigation, and the standards by which this litigation is governed, will determine the fate of all those cases. So anyway, I think it's an interesting case, and I'm grateful that Short Circuit highlighted it.
Of course. Well, Bob, you often do a little work for our newsletter. What's your take on this case?
Yeah, so the thing that strikes me about this case is it's always interesting to read a panel that is so clearly struggling with existing circuit precedent whose premises it just does not want to embrace. Because I think you can state the panel holding very clearly in a way that's persuasive, where it says, look, the ADA doesn't apply to websites, and the plaintiff here actually went to this Winn-Dixie all the time before he even knew they had a website. And so the fact that the website isn't accessible doesn't prevent him from accessing the Winn-Dixie. The Winn-Dixie is the only thing the ADA applies to, and so that's that. Like, the fact that you subsequently found out they have a website and got mad about it doesn't mean you can't go to the Winn-Dixie. And I think, stated that way, it's perfectly logical, and the problem the panel has is earlier 11th Circuit precedent holding that, for example, the ADA applied to Domino's website because you could order a pizza on Domino's and then show up at the Domino's and pick up the pizza. And the panel tries to distinguish that away by saying, in Domino's, you can complete the whole transaction on the website and go pick it up. And Winn-Dixie only lets you apply coupons. You can't actually complete the purchase. And I'm not quite sure that really holds up. I I have not looked at the record in the Domino's case, but I suspect the Domino's plaintiff had ordered Domino's pizzas before he discovered that their website was inaccessible. And so I think David is right that a lot of this really does boil down to how we're going to treat websites generally. And it seems like, the ADA applies to websites or it doesn't apply to websites. But while we are struggling with this, we're going to have panels trying to draw these kind of strange distinctions about exactly what the functionality of the website is and how that relates to the store. When in reality, most of these websites aren't actually going to bar you from the store, and no one thinks they bar you from the store. What we're really talking about is how we want to regulate websites, which I agree with David, seems like a thing Congress has not spoken to. And courts are sort of trying to fill in the gaps in a statute that was written when there really wasn't an internet to speak of.
Yeah, well, the issue in the background is Amazon a place of public accommodation? It seems like probably it's not from what's said here to the extent that it's not physical. But there's this netherworld in the middle here. I also like the dicta that they didn't follow this earlier 11th Circuit case, and they could like to argue that some of it was dicta. But then there's this Supreme Court case, the famous PGA Tour case that the Supreme Court ruled on, where there's dicta that they said, well, that's Supreme Court dicta, and that's a little bit more important, and that actually helped the majority, and so they were going to follow that dicta, but not the other dicta. Of course, we've all seen plenty of cases where dicta is just dicta, and the court can do whatever it wants in not following it. So anyway, another point.
I think we all know that the definition of dicta is language in a court opinion that is not helpful to my position. That's what that word means.
Well, here's another point in a string site if you're trying to argue that. So I would recommend this case if nothing else than that. Well, this is going to be an important one to watch for the ADA and its evolution going forward. So thanks so much, David, for selecting this and giving the conversation here today. We're now going to move on to Bob, that has something that almost everyone seems to misunderstand these days, and that's Section 230. Now, we recently had on someone who actually does understand it, Mike Masnick of TechDirt, where we discussed a Section 230 case from the Second Circuit. Now, Bob has another Section 230 case, this time from the Ninth Circuit, where David clerked, by the way. Maybe he can give us some insights about that. But this one is pretty different than the other case, Lemon versus Snap Inc. Bob, there's some pretty tragic facts here, but some clarifying legal analysis as well.
Yes. So Lemon v. Snap, which is a case out of the Ninth Circuit about Section 230. I have heard that the best way to get attention on the internet is to say false things about Section 230, the Communications Decency Act. And so I intend to get in on some of that action.
A good way to get legislation passed as well.
Exactly. This is how I'm going to make my mark, Anthony. And so the underlying facts in Lemon are tragic. A car full of teenage boys speeding at over 100 miles an hour crashes into a tree, catches on fire, and all the young men die. And it subsequently emerges that while they're driving at these outrageously fast speeds, they're Snapchatting. And apparently, for reasons passing all understanding, Snapchat has a skin you can put on your snaps. It's a speed filter that purports to show the actual speed you're going at the time you've recorded your Snapchat. And I, just speaking candidly as an old person, I cannot think of a reason to have this that is not driving a car at absurd speeds, but they have it. And so the family of the young man sues and says this is a products liability case. You negligently designed Snapchat to put this filter on that encourages people to drive at insanely fast speeds and subsequently to get in terrible accidents. And Snapchat said, whoa, we're immune under Section 230. We are an interactive computer service, and you can't hold us liable for other people's speech on our service. And what the panel says, I think correctly, is this case isn't governed by Section 230. Sure, Snapchat is an interactive computer service, but nothing about this case is trying to hold them liable for anyone's snaps. Nothing's trying to hold them liable for any information published by a third party on their service. The allegation is just that the speed filter itself is a negligently designed product, that doing this caused the accident, even if nobody ever snapped about it. And so the panel reverses and remands. So I think that's correct as a matter of Section 230 law. But what I find interesting about this is that I think it's a good example of how pre-existing rules of law can twist claims into shapes where they're ultimately doomed to collapse. Because I think you can state the plaintiff's claim here in a way that's very intuitive and makes sense. It says, look, Snapchat created this filter. When people use this filter, it encourages people to kind of compete and have snaps that show them going faster and faster. And that kind of interaction is what led to these young men dying. But the problem is that Section 230 would bar that claim. You can't hold Snapchat liable for other people using this skin. And so what the plaintiffs are left saying is that this is just a bad product. It's negligently designed, even if nobody ever snapped anything under that. And I think the difficulty they're going to have on remand, and the panel explicitly declined to address whether they had properly pled that the negligent design caused the accident, is if you take out the what was actually going on, which is other people's snaps were encouraging speeding, you're left with basically a speedometer. This entire skin is just a tool that shows you how fast you're going. And sure, sometimes people who have a tool that show how fast they're going are going to go as fast as they can. But it doesn't strike me as meaningfully different from the car's speedometer. And I can't figure out a way they could have pled this that didn't run squarely into Section 230 that also would have given them a good argument for how Snapchat caused this accident. But it's something you see sometimes in litigation where someone shows up with a square peg and they're met with a round hole. So they take a chisel and they take their square peg and they turn it into a round peg. And as soon as they're through that first obstacle, the court's going to say, okay, show me your square peg. And they say, well, I had it a minute ago. It was right here. And so it's a temporary defeat for Snap. It's a victory for the plaintiffs, but it's a victory for the plaintiffs that seems to set them up in a very difficult position on remand, because their basic intuitive claim is that Snapchat is incentivizing these snaps that show people going absurdly fast. And that's exactly the claim they have had to affirmatively waive in order to persuade a panel at the Ninth Circuit to revive their lawsuit.
David, do you see a round hole or a square peg?
So I think one allegation they did make in this case was, and I don't use Snapchat, it's one of the few social media things I'm not on, but there was some allegation that Snapchat somehow, or there was a rumor that Snapchat somehow incentivizes people, or if you hit a certain speed, you get some kind of prize or a shout out or something. And again, at this stage, I think the panel's supposed to take this as true. So they do have that allegation. But I agree with Bob. I think that this case is correctly decided because under Section 230, the issue is the lawsuit trying to hold the defendant liable as a, quote, publisher or speaker of the information? So if somebody wrote a snap that was defamatory or that violated somebody's privacy, the text of it, if I wrote a snap saying, oh, Anthony is a thief or whatever it is, that Snap would not be liable for because that was on me. But if Snap designs an app that leads people or encourages people to engage in dangerous behavior, then I think they could be liable. So I have an embarrassing confession to make. I've broken this addiction, but for a time, I was very addicted to Pokemon Go. And I actually even reached level 40, which used to be the highest level. And one thing I noticed in Pokemon Go was it doesn't let you you're not supposed to be able to do certain things when you're in a moving vehicle, much to sometimes my disappointment, even if I was a passenger. And you have to click on something saying, I'm not in a moving vehicle, or I'm not driving, or something like that. So apps can be designed so that certain features are not available when you are moving at a speed above a certain level. And it looks like Snap did not do that here. So I think I'm more optimistic about the plaintiff's chances than Bob is. I think that they might have a shot here on remand.
You never almost accidentally walked off a cliff, did you, David? I heard that's a thing.
No.
Pokemon Go.
I think the dangers for Pokemon Go were just to my productivity, but not to my physical person.
I mean, it does raise the question, and the Ninth Circuit notes that the district court hasn't yet decided which state's tort law is going to govern. But the usual products liability question is kind of, could you have gotten the useful part of this product without the dangerous element that the plaintiffs are complaining about? And for the life of me, I can't figure out what the useful part of this product is. Like, what is it for if not teenagers doing this? Like, am I supposed to carry my phone with me at the track and snap myself when I'm going really fast? It seems like 100% of the uses are, in fact, the thing the plaintiffs are going to say was negligent.
Well, it seems to me that the parallel is something like you take a picture of yourself and you can put highlights on your face or put a cartoon hat and then send it to your friend. Those kinds of harmless devices, apps. And so this is doing the same thing, but it's proving that the reality of this dangerous thing that you're doing. And of course, you would never do that if someone else didn't see it. And I think I may be having been a long time since I took torts from Don Marshall at the University of Minnesota. I'm a little bit in the middle of the two of you on what the implications might be, but there does seem to be definitely some incongruity there. And I have to say, when I first started reading the case, I thought, what is Section 230 doing here? This has nothing to do with Section 230, and this must have been a misreading. But the more I think about it, Bob, there is some, although I think some of us are big fans of Section 230 from a free speech perspective, there is some rough around the edges that perhaps case law will straighten out. But it could be something down the road that might need to be given a look at if we have more litigation like this.
Well, it's interesting to me. I kind of like decisions like this because overall, in general, I am a fan of Section 230, and this kind of makes sense. We used to have reader comments on Above the Law. Sometimes they were controversial, and I wouldn't want to be held responsible for those things. I didn't write them, so why should my website be held accountable? So generally, I like Section 230. But I think that it kind of became this monster that took on a life of its own. I think that when it was originally passed, when they referred to interactive service providers, they were probably talking about your internet company, like an AOL or something. And then it got expanded to include websites and blogs and commerce sites and all of these other things. And that's fine, I think. I think it's true when people have these scholarly analyses of Section 230 and they say it's integral to the growth of the internet. Sure, I think that's true. So I like Section 230 overall. But I also like it when Section 230 is cabined by case law, because if the courts don't put limits on Section 230, somebody else will. And whether it's former President Trump or Congress or someone, there's been a lot of talk, as we know, over the past few years about getting rid of Section 230, dramatically cutting it back. And I don't want to I worry with Section 230 reform that the medicine is worse than the disease.
No, I think that's right. The value in cases like this is that it does establish that Section 230 means what it says and isn't just kind of a get-out-of-jail-free card because you are a tech company. And so if, in fact, it turns out that when you go over 100 miles an hour, the Snapchat app lights up and says, "Congratulations on speeding," then you can actually have a solid argument that they're inducing people to do these things. And it doesn't matter that they're an interactive company when they design a product that, gives you special cupcakes as a result of going 100 miles an hour in a residential area.
We sometimes say on our legislative team at the Institute for Justice, especially say an eminent domain statute that's pretty good, but could use a little bit of help, around the edges. We say, well, that law is like a box of chocolates. You open it up, you don't know what's going to happen. And so that could be of Section 230, even the best of intentions. So I like your point, David, about how the courts can keep things reasonable and as they were intended. Well, I'd like to thank our friend David Latt and my friend Bob, and your friend too, of course, for coming on today. This has been an interesting discussion about a couple interesting cases. The next couple weeks, we're going to have some more interesting episodes, including a focus on the Second Amendment and then a focus on non-delegation doctrines and majoritarianism in the state. So both of those should be some fascinating episodes. Please stay tuned for. Please sign up for David's newsletter. And from all of us, we ask you to get engaged.